first matter to come before the court this morning, can you all hear me? Thank you. Is In Re XM. The child's attorney filed a brief, and so did Summit County Children's Services file a brief. So we have two attorneys arguing this morning. We have 15 minutes to present your argument. You may reserve up to 5 minutes for rebuttal. You let me know when you get started. I'm keeping track of the time. We've read the briefs. Please do not use the name of any minors or victims in this case, as we are recording this oral argument, and it will be posted on the court's YouTube channel. Mr. Eckerwall, would you like to reserve any time for rebuttal?
5 minutes, please, Your Honor.
Thank you. We've read the briefs. We're ready to go.
Thank you, Your Honor. May it please the court. Attorney Neil Agarwal, attorney for the child. Your Honor, the facts of this case are not in any dispute. They are long, they are kind of convoluted, and there's a lot of ins and outs. But the purpose of this appeal, the facts are very straightforward. There was a complaint filed by Children's Services of abuse, offense, and neglect. The child was adjudicated. There was a finding of dependency. There was a disposition. Months later, I was appointed as the attorney for a child based upon a conflict. I filed a motion to dismiss. At the time, I had argued there was no effective service on the John Doe father. Children's Services, I don't think, objected to it. We had a hearing before the magistrate. The magistrate granted the motion to dismiss and closed and terminated the case. Children's Services, I think, was in agreement with the motion, or at least as the law they understood at that time. They did not object. They did not appeal. They did nothing to disagree with that decision. However, a month later, they filed a motion with the trial court saying, Your Honor, can you undismiss this case? Can you reinstate this dismissed case? Can you give us back temporary custody of the child that had been given to the mother? And the magistrate, a little over 2 hours later, and the judge granted the motion. And that was it. The case was reinstated, undismissed, went back into Children's Services. The child went back into Children's Services temporary custody on that date. I filed a motion to set aside, or in the alternative, objections to that decision. We had to have a visiting judge because of other proceedings going on in the case. And the visiting judge took about a year later. We kept having hearings and said, I'll give you time to brief the issue, I'll decide. And then about a year later, he came out with a ruling saying, the child's motion to, the objection to this overruled, and the case can go forward, okay? So I appealed that to this court, and I'm making basically one argument, and is that what the trial did in this case, they cannot do. You cannot undismiss a case where there is no objection and no appeal to that ruling. Now, they didn't file a 60B, a Civil Rule 60B motion to vacate. They didn't file any affidavit when they filed their motion to undismiss the case and reinstate it. They didn't present any facts. They didn't call any witnesses. There was not even a hearing. There was no testimony. So, on what basis did the trial court reinstate a dismissed case? It's unknown. When the agency filed its motion to undismiss the case, they put in their certificate.
Did they call it a motion to vacate, or you referred to the motion to undismiss the case? I'd be surprised that's what they called it.
Let's see, they called it a motion to vacate the order.
And but not pursuant to 60B, just no 60B language. Did they ask, or in their motion, did they indicate they were relying upon the court's inherent authority to vacate decisions at all?
No, it was not a common law motion to vacate. It was not a 60B motion to vacate. Basically, what they put in their motion, and again, it's unsworn testimony and everything, is like, we didn't get the journal entry dismissing it, so we want it to be undismissed. And I'm using undismissed because that's the effect of what it was.
Do you agree that they did not get the journal entry dismissed?
No, because when you look at the judge's, the trial court's dismissal entry, when he granted my motion to dismiss, it says right there under the certificate of service, the caseworker was served, the caseworker supervisor was served, CSB legal department was served, and the prosecutors were served. That's all listed in the certificate of service of that journal entry. So I guess they're saying, unofficially, none of us knew about this journal entry.
And if I understand the record below, the trial court asked for people to brief this issue. In the brief, did the prosecutor's office agree that they had gotten service in some capacity, or did they maintain that they still had not gotten service? Do you recall?
I don't recall. All they kept saying is that the trial court had the ability to do this, and Attorney Ireland doesn't know what he's talking about, and I'm used to that. But in the sense that, no, this is perfectly okay. Now, I'm arguing, how does this make sense? How can a trial court, within 2 hours, grant a motion to vacate a dismissed entry and reinstate a case, take custody back from the mom, put the child back in the agency's temporary custody when there was nothing attached to the motion to vacate? No, and this court has held, you have to support your motion or a 60B with more than just bare allegations. You have to have some facts assorted, you have to have some affidavit, you have to have some notice, and then the court did not schedule it for a hearing. This court also said if you're going to grant a 60B, you need to have a hearing so parties can contradict or they can present contra evidence as to why. So here we had no hearing, no testimony, no witnesses, no notice. Agency specifically puts in their certificate of service, we're going to mail out our pleading to vacate 3 days after we file it. We're not going to notify the parties by mail until the court has already had this pleading at least 3 days in its hands. And that's the opposite of what the civil rules say. The civil rules say you can serve 3 days before you file. It doesn't say anything about we're going to notify all the parties 3 days later. So again, how in the world is this even possible? You took the child from the mother and you put the child, and again, the motion wasn't labeled like ex parte motion or emergency or that we have to have it today, and then you schedule a hearing further on it like shelter care. None of that happened here. It was the agency saying basically, we didn't get notice, so therefore, reinstate the case. Now, this court has already held parties have an affirmative duty to check the docket when you're the attorney or the party on the case. So the dismissal entry was docketed, it was uploaded, it was timestamped, everyone knew about it. I certainly got a copy of it, I knew about it, it was there on the docket, and the prosecutor's office and Children's Services had an affirmative duty to check the docket to see if the pleading was there and to be kept and updated. This court has held that many times. So, and then when I argued on behalf of the child, this is a violation of due process, they're arguing, oh, the child had plenty of due process after the fact. But when you look at what due process means, and I have cited it, it means they have to be able to be present to make their arguments in a reasonable manner and in a reasonable time. So at the time the agency filed their motion and the court granted it, where was the opportunity for the parents or the child's attorney to come in and tell the court, you can't do this?
Could you explain to me a little bit about the situation of the child during all this? So you keep saying that the child was pulled back from mom and given to CSB. So when they dismissed, they moved to voluntarily dismiss the case.
It wasn't a voluntary dismissal.
Okay.
The court, I filed a motion to dismiss, and the court granted it.
Okay, I'm sorry, I'm getting them confused. Okay, all right, what happened at that point? Where was the child at that point?
From like a year and a half ago. But I think, well, legally speaking, once the case is dismissed, the child would go back into the legal custody of the mother. And I don't think anyone disputes that. Whether or not that actually occurred or the child was still at foster care.
That's what I was getting at, because it seems like from the court order that did not occur.
I can't tell, Your Honor. and I-
Physical custody did not change.
Yeah, I'm not sure that happened.
At any rate, so if we rule as you want us to today, okay, what happens from there?
Well, what should have happened, and what should happen today, is that if there is a dismissal, and the agency believes at that point going forward, that the child is in an abuse, dependency, neglected situation, they should have filed a new complaint. And it was dismissed without, the magistrate dismissed it without prejudice. It wasn't like they were not able to refile, they absolutely could have. So why didn't they? Why would you go through all the steps to reopen a dismissed case when the court didn't have trial jurisdiction to do that? And just file a new complaint? I have no idea, it didn't make any sense to me.
Well, it's probably for practicalities, right? For practicalities, because they can turn around and file a new case.
Well, that's what I'm arguing, they should have filed a new.
I know, but you said, why did they do it?
No, why didn't they? I'm saying, they should have filed a new case at that moment. When the case is dismissed, and they don't object, and they don't appeal, they are in agreement with that decision. And I think they agreed that the magistrate, when we had the hearing anyways, but regardless, if they still believe that that child was in an abusive, neglected, or dependent situation, they should do what they do literally every day. Go down to juvenile court and file a new abuse, dependency, and neglect complaint based upon the facts and circumstances at that time.
And counsel, I need to let you know you're reaching into that 5 minutes for rebuttal.
Okay, thank you, Your Honor. I'll reserve the rest of my time for rebuttal. Thank you.
Good morning.
Good morning.
May it please the court, my name is Rick Raley. I'm appearing on behalf of the agency today, the Summit County Prosecutor Sherry Beth Walsh. And I'm going to ask that this court overrule the assignment of error and affirm the trial court's judgment. Before I proceed, though, I do have to do some cleanup because 2 days after I filed my brief, this court issued an order in re EH that contradicted directly what I held about dismissal of this case for lack of a final appealable order. Based on that opinion, I will abandon that request and not ask this court to rule on that. It has already been decided. That also affects the substance of my motion as well, because part of my argument was, well, the original order was not a final order. EH already has disposed of that as well. But I do believe that this court still has the ability to affirm the trial court based on the fact the trial court had authority to revisit that prior decision that was issued inadvertently and by mistake. And I do think it's important to outline some particular facts that were left out from Mr. Atkins' presentation. And that is, let's see, the motion to dismiss that he filed was granted on February 9th. The agency was not in agreement with that decision. And in fact, on March 1st, 2022, the agency filed an opposition to his motion, which further shows that there was no actual knowledge on the agency's part that the motion had been granted. And the trial court's own actions as well would further show that there was a belief by the agency and other parties to the case that the case remained active. Most notably on February 15th, 2022, the court issued an order that gave mother additional time to file objections. A review hearing was scheduled and notice was provided during this time period. That review hearing was scheduled for March 31st. And according to the motion to vacate that the agency filed, that was on March 11, 2022. At that time, the case docket reflected that the case was open. So in light of all of that, there was an understanding from the agency that the case seemed to be open. And when they realized there was a pleading indicating that there had been a dismissal granted, a motion to vacate was filed. The trial court does eventually grant that. I will acknowledge that it happened 2 hours after the motion was filed. There was an opportunity in the juvenile rules for the child to then challenge it via a motion to set aside, time to file objections, which were carried out. And then the issue was addressed multiple times for a year, and arguments were fully made, which is why I believe there's been no due process violation in this case. So if there aren't any questions, I would ask the same on that. I do believe the trial court had authority based on the inadvertent issuance of the dismissal, and it had full authority to vacate it. And I really think, go
I'm
ahead.
sorry.
Go ahead.
Well, there's only a couple means you can do that. That's 60B or an inherent authority of the court. So what is your theory on that? Because they didn't argue 60B.
I would have to say that, the way that this is couched is jurisdiction, the standard review that's referenced in Mr. Eggwell's brief refers to the jurisdiction of the court to grant that motion. I think that the Manillo case from the 8th District, which I cite in my brief, shows that the court has full jurisdiction to have granted this motion. And that was proper for it to do, based on the facts surrounding it. So I would go with inherent authority. I think that it might possibly fall under 60A or 60B, but that was not specifically referenced in the trial court materials, so I would say that.
Did the trial court ever make any findings about whether the prosecutor's office had been served a copy of this or given notice of the decision?
I did not see any findings like that. Unfortunately, there was not too much reasoning for the final entry as well from that has been appealed. But I think based on the nature of the motion that was made, the circumstances surrounding it, that's where we get the inherent authority.
And throughout the filings that occurred in this matter, after the decision was granted, the objections and all that, the prosecutor's office maintained that they did not receive a copy of that February 9 decision. Do you recollection?
I can't exactly recall. I don't know if it was specifically said, hey, we definitely didn't get it or whatnot. The only real that was presented, we thought it was open because of all these factors. It was reflected as open. It just was missed that the February 9th order came out.
Were there other children in this particular case?
Not in this particular case, I know.
Not this case, but I'm sorry, this mother, did she have other children?
I believe so, yes.
Do you know if those cases were dismissed at the same time as well, or was it just this case?
I do not know that. I'm sorry.
In regard to the further proceedings, was there any testimony ever presented?
Regarding this particular issue, no,
Was there any affidavits filed?
not that I know of. There are no further questions. I ask you to affirm the trial court.
As far as just while you're here, we got a due process argument from the appellant as well. What do you have to say about the process in this particular case? Particularly the idea that the motion filed, granted, not instantaneously, but nearly instantaneously, and they had no right to, or no ability to comment on that.
So I would, acknowledge before the initial order, there was not a lot of process given. But the juvenile rules do provide for process after the fact, and the motion to set aside proceedings. And I think that there is a reason for that in juvenile court where children's custody is involved. Most of the time, immediate relief is necessary to keep everything at bay when there is a serious circumstance going on. And the law recognizes that there's continuing jurisdiction over a child until they reach the age of 18. So I think due process was given certainly after the fact with all these avenues that were available to Mr. Eggwell. I will acknowledge that for the 2 hours before it was granted, there was not a process given.
And you may have said this earlier, and I apologize if you did. As far as Judge Carr's question as to the child in this case, do you know from the record, was the child returned to mother after February 9, or had the child remained in foster care this whole time?
I have no reason to dispute what Mr. Agrawal said. I think that that's probably accurate.
Well, I think he said legal custody.
Legal custody, yes,
Not
I did term.
physical
Not
custody.
physical.
Not.
I agree with, because Mr. Agrawal doesn't know what he's talking about sometimes. Thank you.
Thank you, counsel. Counsel, you have 4 minutes and 20 seconds.
And I will tell you, Mr. Agnew, it's on videotape, so the prosecutor.
Yeah. It's been mentioned, I got that. Thank you, Your Honor. May it please the court. Your Honor, on page 9 of my original brief, I cite a case that's INRI NK. It's a delinquency case where the juvenile admitted to some delinquencies. He did the diversion program. It was dismissed, I think with prejudice. And then the state filed a motion afterwards saying, we want you to reinstate this dismissed case because the victim wasn't there to testify, and we want to put more stuff on the record. And the trial court granted that and undismissed it and reinstated the delinquency case. And then on appeal, this court said, no, they can't do that. That's not the way you would undismiss a delinquency case. And so we're going to vacate that and reinstate the dismissal. Now, in my reply brief, page 6, I cited a case out of this court, Huggins versus Mitchell, where it says, this court held, prior to the adoption of the Ohio Rules of Civil Procedure, trial courts possess the inherent power to vacate their own judgments. Since the adoption of the civil rules, this court has held that Civil Rule 60B provides the exclusive means for a trial court to vacate a final judgment. That's what this court has held, 60B, and then this court is, and I've cited that the court can't just instantaneously grant a 60B. There has to be grounds for a 60B. It has to be pled with particularity. There has to be a hearing on it. There has to be evidence on it. There has to be testimony on it. And again, they didn't request a 60B, nor did the trial court grant a 60B. And then they cite the 8th District case Milano versus Freeland, which I also put in my brief, but that deals with the trial court's clerical errors. It's not a free-for-all for anything and everything that we can just vacate instantaneously, any prior thing. And then lastly, concerning due process, Your Honor, I want to cite on page 7 of my reply brief a quote from the U.S. Supreme Court, Fuentes versus Shevin. For more than a century, the central meaning of procedural due process has been clear. Parties whose rights are to be affected are entitled to be heard, and in order that they may enjoy that right, they must first be notified. It is equally fundamental that the right to notice and an opportunity to be heard must be granted at a meaningful time and in a meaningful manner. So, as Justice Stevenson was asking, what about this just almost instantaneously, 2 hours after the motion's filed, case is reopened, child goes back into the agency's temporary custody? Where was anybody's reasonable time and reasonable manner to contest that? Where was the opportunity even afterwards before the trial court? Where was the, and again, they're saying, I understand for an emergency motion, we have to take emergency custody to protect this child. I get all of that. But none of that was done in this case. It wasn't an emergency. It wasn't an ex parte. We have to maintain temporary custody of this child for the health and protection of that child. It was like saying, we just think that the trial court made a mistake and we want you to reinstate the case. And that was it. So the only opportunity I had is after the case was, where the child was, after the child was placed back in the agency's temporary custody. That's not a meaningful time or in a meaningful manner. It has taken the judge, I'm not saying it's anyone's fault, but it's taken the judge more than a year after I filed my objections to say, no problem here. And what was the magistrate's ruling for reinstating it? It's unknown. What was the judge's basis for denying my objection? It's unknown. So nobody has given an explanation under what grounds the trial court had the ability to do any of this. I'm still at a loss. It's not they didn't ask for a common law. They didn't ask for a 60B. It wasn't granted under those grounds. So I'm asking the court to do what the trial court should have done. Say, motion to vacate denied. If you have concerns, file a new complaint, and then we'll address it at the appropriate place and the appropriate time, with due process to all parties. So in conclusion, Your Honor, I would ask the court to sustain my assignment of error and vacate the trial court's entry of reinstating this case. Thank you.
Thank you both for your presentations this morning. I apologize. Sometimes when you're fine and then you have this restriction in your breathing, it causes some issues. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the House Supreme Court website. Thank you, gentlemen.
Thank you.
Thank you, Your Honor.